Good evening, and my name is Claudia and Edward, and I'm the first presenter. First, I'm to explain the question 1. The issue in question 1 is whether Salim, who is an investor, intend to take action in a court against Sarah to settle dispute about his losses. The second issue is whether Tekun Niaga Berhad take action to sue Sarah for their losses suffered. In investing, Sarah as auditor should to have a duty of care and skill. Sarah, who is an auditor, not to use company information to gain advantages or benefit for herself. It is important for her not to conflict her interests with the company interests. Under the common law also, an auditor may own duty of care and skill to person other than the company itself, even though there is not contact between them such as the investor and client. The auditor The auditor may be liable to third parties for their losses as a result of negligent audit done by the auditor. There are cases where the court may find the auditor liable to a third person who rely on the audited account if there was exciting relationship formality between the auditor and the plaintiff. That's all. To Section 216, an auditor shall in a report under the subsection A whether the financial statement and is the company is a holding company for which consolidated financial statements are prepared. The consolidated financial statements are, in his opinion, properly drawn up. In addition to subsection Roman 3, in accordance with the applied approved accounting standard, or in the case where the financial statements are required to be prepared for or lodged, which the authorities refers to in section 26D of the Financial Reporting Act 1067. Such financial statements shall be made in accordance with the applied approved accounting standard, subject to any certified guidelines or regulation as may be issued by the authorities. Accordingly, the section 216 subsection 8, if an auditor in the course of the performance of his duty as auditor of a company is certified that subsection A, there has been a breach or non-observance of any of the provision of his acts and subsection, the categories are such that is, in his opinion, the matter has not been or will not be accordingly dealt with by comment in his report on the financial statement or consolidated financial statement, or by bringing the matter to the notice of the director of the company, or if the company is subsidiary of the director of its holding company, she shall forthwith report the matter in writing to the register.
I'm Philomena Umbi. I'm Presenter application to apply the law above as a sole auditor according to section 266 subsection 9. No duty to which an auditor of a company may be subjected to shall be regarded as having been contracted by reason of his reporting the matter referred to subsection 9 in good faith to register. Sarah should not be negligent in preparing her audit in compliance with the legal framework. First, acknowledge to her Salim, an investor who has suffered hard loss due to his reliance on Sarah audit account. Want to initiate legal proceeding against her. Sarah should have known the consequences to Salim of her action. Second, Sarah had also given her good advice to the company to extend creditor of SL holding after being certified that it was appropriate to do so based on their current financial status and position at the time and acknowledge to her the unprecedented worldwide outbreak. This happened please soon after Excel Holding was unable to settle their debts according to their signed contract. Sarah breached her duty by giving wrong advice to the company. In conclusion, Sarah as an auditor must be independent, ensure an unbiased perspective, and allow financial statements to be more reliable. Firms face the risk of damage their reputation once auditors fail to report mistakes in their auditor. For example, Sarah did not do her auditor sensibly and has caused a hard loss of the company. Question 2. Issue whether Azlan's termination was done in accordance with the right principle to procedure under the Company Act 2016. Whether Bosco Sendiran Berhad delayed submission of annual return as consequence under the Companies Act 2016. An auditor is an independent professional authorized to inspect, review, examine, and verify the accounts of business record to ensure true or fair account, past financial performance, and current financial position. Hence, the function of an auditor is to ensure the financial information as to the company prepared by the director precisely reflect the company position. In section 276 of the Company Act 2016, an auditor can be removed from office by member at any time by passing an ordinary resolution at the annual general meeting, in which a special notice of the resolution should be given at least 20 days before the scheduled member meeting in section 322 Companies Act 2016. An auditor may be removed or terminated from the office before the expiry of his or her term. By referring to section 277, the auditor may make a written representation within 7 days of receive the notice and to have the right to be heard at the meeting. Next, the auditor may request a copy of representation to be circulate or read to every member at meeting. The auditor may be removed at the general meeting by resolution passed by a majority of vote which is more than 50% of member, and another person can be appointed as an auditor at the same time. Moreover, in section 297 subsection 2 provide prohibit the removal of an auditor by a private company by passing a written resolution. The company is required to give a notice in writing of the removal to the registration within 40 days after the removal, in which the registration would appoint an auditor if the company did not appoint a new auditor under section 270X, and the auditor cannot be removed by the director.
Based on the section have listed above, we can conclude that Azlan should review the contract to determine if the termination was done within the agreed upon procedure and grounds. As for Bosku Sendirian Berhad, they should providing Azlan with the right principle and procedure under the Companies Act 2016 as stated above. Other than that, Bosku Sendirian Berhad suspected for terminate or Azlan was removed in the Mala fights, or in other words, was in bad faith. This occurred because Bosku Sendirian Berhad failed to follow the procedure to terminate or remove an auditor based on the Companies Act 2016 by a resolution passed by a majority of votes, which is 50% of members. For the principle with regards of annual return, the relevant law for this case is in Section 68 of the Companies Act 2016 set out the requirement for companies to submit their annual return within the specified time frame after the company anniversary. Next, in Section 68, Companies Act 2016, subsection 8, the registrar may strike a company off the register as provided in Section 549, which is stated that the registrar may exercise his discretionary power to strike a company off the register if he has reasonable cause to believe that the company is not carrying on business or the company is not in operation. If the company fails to lodge an annual return for 3 or more consecutive years. The relevant case related to the law listed is Rigaware Global Sdn Bhd Suruhanjaya Syarikat Malaysia 2020 is a Malaysian case where the court imposed penalties on the company for late submissions of statutory documents, highlighting the consequences of non-compliance. According to the relevant case and law have stated, we can conclude Bosku Sdn Bhd should rectify the non-compliance by promptly submitting the outstanding annual return. They should also establish process and system to ensure timely compliance with future filing requirements. This will demonstrate the commitment to adhering to the provisions of the Companies Act 2016. In conclusion, the application of the correct principles of law in the case involves considering the provisions and insigniables under both the common law and the Companies Act 2016 for the issue of Azlan termination, it to evaluate whether the termination process follow the principles of procedural fairness and whether there are grounds for claiming wrongful termination based on breach of employment contract or law protecting auditor from unfair dismissal under Contract Act 2016. Regarding the defaulted submission of the annual return by Bosco Sdn Bhd, the focus should be on rectifying the non-compliance by promptly submitting the outstanding annual return and implementing measures to ensure future compliance. It is important to understand the consequences of non-compliance, such as penalties, fines, reputational damage, and potential legal action, and take necessary actions to mitigate these risks.